Are defendants' constitutional rights violated under the Sixth Amendment by the introduction of a CJA report? To find out, you have to read People v. Franklin, but it's 28 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People v. Franklin. The citation for this case is 2024 New York Slip Opinion 02227, published by the New York Court of Appeals on April 25th of 2024. The issue in this case is whether an interview report prepared by a criminal justice agency employee can be admitted at trial, or if instead that violates the defendant's Sixth Amendment rights to confront his accusers. To understand and appreciate the background of this case, it's helpful to know 3 different things. First, that the Sixth Amendment to the United States Constitution, it's part of the Bill of Rights, guarantees a bunch of different rights to the defendants in criminal proceedings. Those include the right to a speedy and public trial, the right to an impartial jury, but important for this case, it's the right to be confronted with the witnesses against him. They talk about, in subsequent cases, examining the Sixth Amendment, including Crawford versus Washington, which I'm going to talk about in a second, that the colonists were concerned about being tried by affidavit or tried by documents and not by witnesses you could cross-examine. And for that reason, I'll go to the next thing that's helpful to know is Crawford versus Washington, which is a United States Supreme Court case from 2004, which held that you can't be prosecuted and convicted by testimonial statements that are not in the form of confrontation, in the form of witnesses that you can cross-examine. They say where testimonial statements are at issue, the only thing sufficiently reliable to satisfy constitutional demands is confrontation. And what does testimonial mean? They say, what is testimonial? It's a solemn declaration or affirmation made for the purposes of establishing or proving some fact. That's what testimonial means. So if it's something that's going to be trying to introduce, if you're introducing evidence of a fact that's important, that would be testimonial under Crawford. The last thing you have to know is that CJA is called the Criminal Justice Agency, and it's an agency, it's a not-for-profit in New York City that does a lot of what probation would do. Outside of New York City, probation departments interview all arrestees before they're arraigned to get certain information. Inside of New York City, CJA does that. They interview all arrestees to determine the suitability for pretrial release. They're examining them, they're asking them questions and taking down the answers to be able to give a recommendation to the judge, the defense counsel, and the prosecutor about whether the judge should be releasing them without bail, releasing them with bail, special conditions that should be imposed. To that end, the CJA employee asks questions about community ties, warrant history, arrestee's address, how long they've lived there, employment status, stuff like that. The CJA employee records those answers and then verifies them if they can, and then prepares that recommendation that they give to the court, prosecutor, and defense counsel. What are the facts in this case? The facts are that there was a road rage incident in which a person was alleged to have displayed a gun, a silver pistol, in the course of the road rage incident. The police ultimately were called. They respond to the defendant's house following up on that incident. And in that house, it turns out that the defendant lives there along with his son and his stepmother. Officers discovered a gun in the basement closet of the house, along with objects that belonged both to the defendant, Mr. Franklin, and the stepmother. The defendant was arrested, and while in Queens Central Booking, while he's about to go in front of the judge for arraignment, he's interviewed by the CJA employee, who asked him all those questions we talked about. Here, the CJA employee asked what his address was, and the CJA employee wrote down that the defendant said his address was 117-48 168th Street, basement, or BSMT, which the CJA employee wrote down. The CJA employee then indicates that they verified this information with the stepmother. The people that's used at arraignments, and later on, the people use that form where the defendant identifies his location as he lives in the basement of that house. The people make that part of their case, an important part of the case. No other DNA or fingerprints link the defendant to that gun on the gun itself. So to prove that Franklin had dominion and control over the area where the gun was found, the people use that form. By the time of trial, the CJA employee wasn't working there anymore, so the borough supervisor for CJA testified instead, and they introduced it as a public document or a business record. The defense counsel objected and said, this violates my Sixth Amendment right to confront my accusers. You can't do this. It's testimonial. The court rejected those arguments, admitted it as public document, and the defendant was found guilty of second-degree criminal possession of a weapon. He appealed. The appellate division reversed, found that it was a violation of his Sixth Amendment rights, and it goes to the Court of Appeals. And the question here is, were the defendant's confrontation rights violated by the introduction of that CJA report? Was it testimonial? They now give the holding here is that they give sort of a refinement of the testimonial definition. They say, precedent confirms that an out-of-court statement is testimonial when, viewed objectively, all the circumstances indicate its primary purpose was to create an out-of-court substitute for trial testimony. So as to this CJA report, it's not testimonial. Why? It's introduced as a business record or public document. It was not created to prove a fact at the trial. It was for an administrative purpose. It's produced. The holding here is that CJA reports are produced not to create evidence, but for administrative purposes to help at the arraignment. And secondly, they indicate that this was rather the defendant had self-reported his residence as the basement, so it wasn't really the CJA employee's conclusion. And that's basically the case. The goal here, the primary purpose is to give the arraignment judge information needed to make a pretrial bail determination. And it's the same information. Importantly, it's the same information collected from each arrestee, not specific to individual crimes. There is a strongly worded dissent here by Judge Ahrens, who thinks it is testimonial. But once again, the holding in this case by the majority is that CJA reports, interview reports, are not testimonial. Therefore, it does not violate a defendant's Sixth Amendment right to receive the interview report in evidence against them at trial. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.